I want to continue down Senator Grassley's line of questioning about position changes of the Solicitor General's office. While you're the acting Solicitor General, I want to speak about a specific case, namely Terry versus the United States, is concerned with crack cocaine sentencing reduction. The United States had been defending this sentence, which is typical in criminal cases, even if it's a close call, even if the government thinks the case may be overturned. But in March, while you were the acting Solicitor General, you waited until the very last moment. In fact, the very day the brief was due, and sent a letter to the court saying that the department had changed its mind following the change of administration. Not only that you wouldn't defend the sentence, but you confessed error, saying the department had been wrong all along. This required the court to reschedule oral arguments. In fact, this is what the court said in its opinion. On the day the government's brief was due, the United States informed the court that after the change in administration, it would no longer defend the judgment. Because of the timeline, the court rescheduled argument, compressed the briefing schedule, and appointed Adam Morterra as amicus curiae to argue in support of the judgment. He has ably discharged his responsibilities. Now, I haven't practiced law in a long time, but that sounds to me like a court that is somewhat displeased the government switched its position at the very last moment in a way that caused them to reschedule their briefings. But here's the thing. Once the government switched its position and the case was argued, it wasn't a close call. It wasn't 5-4 with some anguished majority opinion saying that, well, it's a really close judgment. We understand the dissent's point. The government lost 9-0. And the only reason you lost 9-0 is there aren't 11 Supreme Court justices. The government, in fact, the court said that the government was engaged in sleight of hand. Ms. Prelogar, how did your office get it so wrong? You said that you went through evaluating U.S. interests and what's the best understanding of the law. And just weeks later, the Supreme Court ruled not 5-4, not 6-3, 9-0 that you were wrong in the Terry case. How did your office get it so wrong?
Thank you for that question, Senator Cotton, and I appreciate having the chance to talk about that case. I certainly found that to be a very difficult decision in making the decision that we should ultimately confess error in that case, which is a longstanding tradition within the Solicitor General's office when we determine that that's appropriate in the interests of justice. I did focus on the legal issues involved and ultimately the interests of the United States. The question in that case is whether the lowest level crack cocaine offenders could be eligible for resentencing under the First Step Act. It was a given that the individuals who were responsible for greater quantities of crack cocaine fell within the provision. And so the only question was whether those lowest level offenders also could get that kind of sentencing relief, the possibility of it under the First Step Act. That was a question that had divided the circuit courts. Circuit judges appointed by both political parties had disagreed on that issue. And ultimately, after looking at all the tools of statutory construction, the text of the provision, the context, the purpose, it was my judgment that Congress had intended to extend that sentencing relief to the low-level offenders. The court...
I'm sorry, our time is limited here, but I mean, do you think having switched the government's position and then being rejected 9-0 just a few weeks later by the Supreme Court, I mean, do you think you got that decision wrong?
Well, Senator, I certainly respect the Supreme Court's decision and the fact that the justices disagreed with our position in the case. Ultimately, I wish that we could persuade the court of our position in each and every case, and I can't quite bat 1,000 like that, but ultimately, as Justice Sotomayor observed in her concurring decision in the case, the ball is now in Congress's court if it wants to extend that kind of sentencing relief to the low-level offenders.
After having joined the majority 9-0 opinion that said it was not a close call at all, that letter was submitted on March 15th. Are you the one who personally made the decision to confess error in the Terry case?
I am, Senator. I was the acting Solicitor General at that time, so I was responsible for all of our litigating positions on merits cases in the Supreme Court.
Did any higher-ranking official in the Department of Justice direct you to make that switch?
No, Senator.
Did you consult with any higher-ranking official in the Department of Justice?
Well, I don't think it would be appropriate for me to discuss internal deliberations at the Department of Justice. I can tell you as a general matter that the Solicitor General's offices solicits viewpoints and perspectives from all interested components. That can include the leadership offices. It can include the federal agencies and, of course, the litigating components as well.
And you'd said in your response to Senator Grassley that one of the things you do is go to litigating components and agency with equities. The acting Attorney General for the Office of Legal Counsel, when he testified in front of this committee a few months ago, said he was not consulted in this case. Would it be the Solicitor General's normal practice to go to the Office of Legal Counsel on a question like this when you're thinking about switching the legal position?
So as a general matter, no. When a matter is in active litigation, the litigating components handle that rather than the Office of Legal Counsel.
All right, well, my time's expired. As Senator Grassley said, this is part of a pattern. This is just the most egregious case since the government switched from its previous position and then lost 9-0 at the Supreme Court. I can keep going if the chairman wants me to.
Pardon me,
I can keep going if he doesn't have anyone else to ask questions.